Ms. Pierce, it's alarming.
His letter?
No, what you did. Not his letter, what you did. Why do you think there's something wrong with a father writing a letter when the mother of his child is driving recklessly in a motor vehicle and has a kid in a car unrestrained and causes severe injuries to the child? Are you proud? What do you think of that?
She was in a seatbelt and.
How old is she?
She's 6.
Okay, what's the law in the state of Michigan? Can you put a 6-year-old in a seatbelt? Is that what the law says to do? Your kid was in ICU. She's got facial lacerations that have required plastic surgery.
And I understand all that, and I'm the one who was with her through all that, not her father. He wasn't there before or after.
You're also the one that caused it. Your actions caused this severe injury to your child. Yes or no?
Yes.
It's almost done.
And you got a 5-year felony reduced by the prosecutor's office, not me, Wayne County Prosecutor's Office, dismissed 2 felonies and let you plead to misdemeanors. So all you're getting on this is, what's the recommendation? Some probation. According to his letter, they had to give you a car seat at the hospital because you went up there without one to get her.
He gave my sister a car seat. I was unable to drive. I couldn't get up there. I have my own car seat for her. There was a CPS investigation. And
Why wasn't it in your car on the day this happened?
I'm a single mother. I dropped her off at school in her car seat. My brother had his baby that morning, and I picked him up from the hospital. I removed my car seat to place his. I thought I had enough time to go back, and I didn't. I can't call her father to come pick her up because he's never there.
You made a really bad decision.
I know I did, but I was there for her and he wasn't.
Well, this isn't an indictment of him. This is an indictment of you.
No, I know.
You were you're operating with no license.
And that I didn't know because they sent the wrong paperwork to the wrong address.
See, what I hear from you are a bunch of excuses, right? Like, it's not your fault because the dad wasn't around. It's not your fault because you didn't have a car seat that day because something else came up. It's not your fault. You didn't know your license was suspended. Like, this is all, I want to be clear. When you look at your daughter and you see that injury on her forever, it is all your fault. This is all your fault. You made a terrible decision that day. And it's like the lack of accountability or acknowledging that is incredibly frustrating. Kara, do you have anything you want to add?
Kara Gross on behalf of probation. I put everything in my PSI report. She reviewed it. There was no corrections or deletions. I included the restitution request and the victim statement. I know that she has enrolled in therapy. I think that's going to be extremely beneficial for her. I hope it helps her make better decisions in the future.
She's still smoking her weed? Were you smoking weed that day while you're driving your kid around, causing serious injuries?
She's a medical marijuana card now.
Did we review it? Is it from a real doctor with real information on it, or is it from Dr. Cron?
No, it is from a real doctor. You did request her to get another note from the doctor that is attached to the front of the file.
I mean, I don't know what this new letter adds.
It doesn't really
address the things that we would request. So she can have a hearing on her medical marijuana card. I can't stop her from using it according to the law. in the state of Michigan. I can't stop her from using it until we have that hearing, right? That's my understanding. So go ahead and smoke your weed while you're driving around with your kid in your car on a suspended license, because that'll help. That'll help your anxiety. All right. Anything else?
No, Your Honor.
All right, fine of 50, court costs of 50, state costs of 50, and a crime victim's rights fee of 75, probation oversight fee of 800, community service fee of $10 a day for a total of $100, and restitution will be determined at a later hearing if necessary. Was there another motor vehicle involved?
There was a second individual. I did just get that information. It's been forwarded to the prosecutor, but it's not gonna be handled today.
24 months, this is a sentencing agreement with Wayne County Prosecutor's Office. 24 months probation, you'll have 10 days or 80 hours of community service in the city of Taylor, or as directed by probation, provide proof. You abstain from the use of possession of alcohol and controlled substances unless prescribed by a physician with documentation, and that'll be for the term of your probation. You'll be subject to random drug and alcohol testing as necessary at your expense. You'll continue mental health treatment as directed by probation and follow all therapist recommendations and provide proof. You'll complete parenting program as directed by probation through nationwide ARM program and provide proof and follow therapeutic recommendations. You'll attend and complete any other ancillary services deemed warranted. You'll maintain employment and provide proof. No operating a motor vehicle without a valid license. And if you've not been printed, you must be fingerprinted. As to the bond violation, did she have that card when she was smoking the marijuana? When she tested positive, did she have a card?
I believe she got the card a day or two before that bond violation was held.
Did
So
she, when the test was positive?
I was never tested.
No, she was not tested. She admitted to using marijuana and that.
Well, I mean, she's got a medical, I'm just dismissing the violation. It doesn't, there's nothing I can do about that at this point. I mean, except for, unless her doctor's going to give us what we need to know by law, then we're gonna have to have a hearing on it.
I can have a hearing set.
All right. Hold on. I'm adopting the recommendation in its entirety, dismissing the violation of probation. Ms. Pierce, you need to take some accountability and you need to make some big life changes. Do you understand that? Is that a yes? And I know you think I'm being hard on you, but you were charged with 2 felonies. You got them reduced to misdemeanors. Not because of me, but because of the prosecutor's office. And I just, when I see someone come up and tell me excuse after excuse about why this isn't their fault, this is your fault.
I wasn't trying to say it wasn't my fault. You asked me the events leading up to it, and I told you the events. I wholeheartedly, every time I look at my daughter, know what I did. And I can't go back and change that, but I know what I did.
Make better choices. You've got little people counting on you. You can't, you know, it's pretty egregious harm over something as simple as getting a car seat. I mean, you're all set. Meet with Kara.
Let's take a step back and break down exactly what we just witnessed. Because beneath all the interruptions, objections, and sovereign citizen jargon, this courtroom exchange is actually a textbook example of how the legal system responds when someone refuses to engage with reality. At its core, this case wasn't about secret jurisdictions, admiralty law, or artificial persons. It was about a criminal defendant standing before a statutory court with lawful authority under the state of Michigan. Judge Oakley made that clear early, and repeatedly. District courts derive their jurisdiction directly from state law. They do not operate under admiralty law. They are not common law courts. And no amount of semantic gymnastics changes that. One of the most important moments came when the defendant insisted that a crime cannot exist without a named injured party. That argument pops up constantly in sovereign citizen ideology, and it's legally incorrect. In criminal law, the injured party is often the state itself, acting on behalf of public safety. That's why cases are titled The People versus an Individual. Judge Oakley didn't dodge that claim. He addressed it head on and ruled decisively. Another key point worth highlighting is the confusion around the probable cause conference versus the preliminary exam. The defendant repeatedly argued that his rights were violated because he believed these were separate mandatory hearings. What the court explained patiently multiple times is that a probable cause conference is essentially an administrative pretrial discussion. The preliminary exam is where probable cause is actually evaluated. That hearing was scheduled for today. No rights were waived. No procedural trickery occurred. And yet, despite being given multiple opportunities to proceed, ask questions, or even accept representation, the defendant chose confrontation over cooperation. That decision mattered. Courts operate on procedure, decorum, and clarity. When a defendant repeatedly interrupts, refuses direct questions, and attempts to control the courtroom, the judge is left with limited options, and contempt becomes inevitable. The contempt ruling here wasn't about silencing dissent. It was about preserving the court's ability to function. Every defendant has the right to be heard, but no one has the right to hijack proceedings or ignore lawful orders. When the judge imposed fines and ultimately jail time, it wasn't personal, it was procedural. Actions have consequences, especially in a courtroom. Now here's the bigger takeaway, and this is where I want to hear from you. Do you think cases like this are driven more by misinformation or by a refusal to accept authority altogether? And if you were in that courtroom, would you have handled this differently, or would you have made the same choices knowing what was at stake? Legally speaking, the outcome here was predictable. The court asserted jurisdiction. The defendant preserved his right to appeal, and due to his own conduct, the preliminary exam couldn't even be completed. Ironically, Judge Oakley later acknowledged something crucial. Had the defendant simply remained silent or followed basic procedure, he may have actually had a better chance at moving this case forward strategically. Instead, the behavior on display ensured delay, detention, and a far tougher road ahead. This case is a reminder that the courtroom is not the internet. Scripts don't work, catchphrases don't override statutes, and belief does not replace law. Reality wins every time. And now, I want to hear from you, because these cases spark strong opinions. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Trust me, you won't want to miss what happens next.